Hello, good afternoon, everybody, and welcome to this webinar that is hosted by Majeure and ATA Insights. For those of you who don't know me, my name is Gurmeet Kaur, and I'm board member of Majeure, and I've been on the board for a couple of years. I'm also a partner at Pinson Masons, which is a global law firm that specializes in energy and infrastructure projects. And we're very fortunate to be named Legal Advisor of the Year for 2 years in running for our work in solar projects around the region. My practice itself covers all forms of energy, and in particular solar, and I've worked in the region now for over 13 years, and that is covering solar schemes across different countries in the region, such as Jordan, Egypt, UAE, Saudi Arabia, etc. And so I'm very familiar with the risk allocation issues that come up in solar projects. And I advise on all aspects of projects, advising governments, developers, suppliers, and also different forms of solar technology such as PV and CSP. And I'm very happy today to be able to do this webinar with my colleague Jed Savager, who is a partner in Pinson Masons, and also Julian Haslam-Jones, who is a director at HKA. And I'd like to just ask Jed and Julian to say a few words to introduce themselves.
Thank you very much, Gurmeet. My name's Jed Savager. I'm a partner at Pinson Masons. My focus is on construction advisory and disputes. So in broad terms, that practice comprises project advisory work during the course of a project, protecting the parties' rights and entitlements, but also right the way through to formal dispute resolution, mainly arbitration in this part of the world. And in terms of those sectors, very much like Meet, I work in the energy and infrastructure space. So major energy infrastructure projects is really what I get involved in, and that's through not just the UAE, that's Oman, Egypt, Saudi Arabia, Kuwait, etc. It's very good to see everyone today, and I'll hand over now to Julian.
Thanks, Jed. My name's Julian Haslam-Jones. I'm a director at the HKA, based in our Abu Dhabi office in the UAE. My background is initially I started working in commercial side of construction, and then I transferred into the claims side of it. I'm dual qualified. I've got a technical and a legal background as well. And what I've been involved in heavily is obviously managing projects from a commercial point of view, but then also in the second half of my career, building claims for clients, whether an extension of time, disruption, or prolongation costs. And then seeing that through, often working alongside the likes of people like Jed and Gurmeet through the dispute process and supporting that from a technical point of view. And it's a real pleasure to be here today, and I look forward to talking to you all.
Great. Thank you very much, Julian. I'm now going to share my screen to get to the presentation for this afternoon. Can you see me? Can everyone see the screen? Apologies, it sort of didn't quite work as planned. There you go. Hopefully you can all see that now. So today's topic is on key considerations for COVID-19 claims in a solar project. And what we are going to cover today are a few items. Firstly, the legal basis for claims. In particular, I'm going to focus on force majeure and change in law. Then we'll look at types of relief, causation and mitigation, and quantification of claims. So firstly, before I go into the details of claims, let's just talk about the impact that COVID-19 has had. I think no doubt 2020 will go down as a year where there has been tremendous challenges in the region and globally. And so in the region here, we've had COVID-19, we've had declining oil prices. Obviously, on the positive side, you've had the UAE-Israel Accord, which brings a lot of new economic developments to the region. And all of this will have an impact on the economy, the government budgets, and the overall outlook for the Middle East. And COVID-19 has had a very direct and indirect impact on projects. It depends very much on the stage of the project. So whether it's pre-closing, whether it's during the construction phase or the operation phase, the impact that's faced is going to be slightly different. But this chart here just shows you some of the ways in which COVID-19 has impacted. We've had disruption in movement of materials and goods. We've had obviously enhanced safety measures that had to be installed on site. There's also been lockdowns of varying duration in different countries, reduced working hours, etc. And all of this has had an impact on time, resulting in delays in some cases, and budgets where clients are facing increase in cost as well. And so the types of claims that we are seeing in this region, where we've been advising a number of contractors and developers, have been mainly in the areas of force majeure and change in law as a result of COVID-19. So I'd like to now turn into the details of what we mean by force majeure type claims. And before I get into that, just a small word of a distinction between the common law approach to for force majeure and the civil law approach to this. So under common law, such as English law, force majeure is really a creature of contract itself, and therefore you need to review the contract and look at the contract itself as to the forms of relief that can be obtained. And under the civil law, which fortunately most of the MENA countries fall under, we do have some protection that is afforded by law. For example, in the UAE, under Article 273 of the Civil Code, there is provisions that allow for relief for force majeure events. While there is no definition under the Civil Code itself for what is a force majeure, and this will be decided on a case-by-case basis, it is usually the position that such an event must be unforeseeable and unavoidable. And also what's important is it must render performance to be impossible. So my colleague Jed will talk about this a bit later on. And what I'd like to now do is just to look at some example clauses that we've seen in the region. So what I've set out in this slide is an example from a regional PPA for a solar project in the region. And as you can see, the PPA has very detailed drafting. There is quite a comprehensive set of clauses. And basically, it's quite a broad definition. What it requires is that the event itself must be outside the control of the affected party. And what's very important is that the event itself must prevent performance. So if you look at clause B, it does require that it prevents performance. And this is quite a high hurdle to overcome. So mere hindrance or delay in performance would not satisfy this clause. So for example, if a contractor had to impose extra safety and health measures on a site, and this results in extra costs and time, arguably it doesn't really satisfy this threshold, because what's required is actually prevention of performance. On the other hand, if the contractor can't get to site because of lockdowns, etc., arguably it would fall under this clause. So I think that's an important distinction. You would also see that there is often a duty to mitigate, as in paragraph C, and there are a few other hurdles that will need to be overcome. What's also interesting in regional PPAs is that the force majeure is divided into what's known as natural force majeure events, and also sometimes it's called political force majeure events, sometimes it's called Offtaker risk events. So in this example here, you see an inclusive list of what's a natural force majeure. And helpfully, it does specifically refer to epidemic or plague. So COVID-19 should fall within this definition, provided obviously all the other hurdles are met. And one thing that's not on the slide, but which I'll also mention, is often the force majeure clause will include a list of what is not a force majeure. And in this case, it did include a provision that delays resulting from reasonably foreseeable unfavorable conditions are not considered force majeure. And this brings me to the next question that we're going to discuss. But before we get to the discussion point, as a contrasting clause, I've just set out here on this slide what FIDIC Silver Book 99 states. And as you can see, it's very similar. It has a pretty broad definition. It requires the event to be beyond a party's control. And interestingly, in the list of examples, it does not specifically refer to epidemic or plague, but notably, it does require that the party must not be able to reasonably provide against the event before entering into the contract. And this requirement for foreseeability is something that we're also seeing more often now in the region, in particular for other projects such as water projects, where in one recent example, the clause specifically referred to the force majeure event not being within the, I guess, reasonable foreseeability of the parties at the time of signing of the contract. So I guess this brings me to my question to the speakers as to how you're seeing parties deal with contracts now to protect themselves against the requirement for foreseeability, because arguably COVID-19 has been in the region now for pretty much a year, and it is well and truly foreseeable. And in fact, now with the announcement of the vaccine and things like that, arguably, with wave 2 and wave 3, there's a risk that this is not going to be protected under the force majeure provisions. So perhaps I could turn to Julian for his thoughts.
Thanks, Gurmit. Unfortunately, what I'm seeing in the market at the moment, and this is just based on my own experience, I know Jed's going to come with a different angle that I think is probably a more practical way forward. But unfortunately, what I've seen just at the moment is the employers passing the risk of COVID-19 onto contractors, or attempting to do that when discussions on the terms and conditions are happening. And this can be either very clearly done with an actual clause that very clearly sets that this risk with the contractor, or the alternative which you touched on before, which is not really dealing with the force majeure clause as it is, and so therefore there's going to be an argument that this was foreseeable and known at the time of signing the contract. So that's what I'm seeing at the moment, or one of the things that I'm seeing. I have to say, from my point of view, I don't think this is a practical or a suggested way forward. I do think that it's better to have this clearly set out in the contract, and for the risk to be shared as it normally would in these kind of events. But unfortunately, that's what I'm seeing in the market at the moment.
Thanks, Julian. As Julian was saying, so we've got two different approaches in the markets at the minute. One's a very onerous approach, which is the as you'll see on the left-hand side of the screen, where all of the risk for COVID, both past, present and future, is being passed on to the contractor. Whereas elsewhere in the market, in particular in the solar space, we've outlined a more balanced approach that's being taken by developers in relation to the balance of risk. And in that scenario, what we're seeing is that, yes, past effect and what we know now
Yeah, we don't hear you.
Speaking, but you'll see Gurmeet, please don't attribute my comment to Gurmeet. I'm sure she won't appreciate it. But I'll just pick up, sorry everyone, where I left off, which was I was explaining the different approaches to balancing risk that we're seeing in the market. I was then just moving on to say, look, if we were on the left-hand side of the screen where the contractor is bearing all of the risks, is that truly enforceable, and what sort of arguments might one advance in order to overcome that? And certainly in this part of the world, in the Middle East region, as we all know, many of the countries are based on the civil code as developed from Egypt, and they include, as many people will be aware, two important doctrines. One is good faith, and two is the doctrine of abuse of rights. And the doctrine of abuse of rights under, for example, the UAE Civil Code provides that it's not permissible for a party to rely or insist upon a right if it would cause disproportionate harm to the other party. And one can see in the context of where we all hope life is going to get better, not worse, but if there were unforeseen extreme effects of COVID in the future, one could see contractors relying upon that sort of provision, which is mandatory. You can't contract out of it, in order to say, look, hang around, this is causing me disproportionate harm in relation to an event or the effects of which now we didn't foresee at the time of contracting and are able to control. And the other bit, Julian, I just thought it might be worth you touching upon is, in that context, is the importance of tender queries, tender clarifications. Because when you're at the back end of a dispute where I'm often operating, what one is often trying to do in terms of construe these clauses and raise arguments like abuse of right, good faith, is to say, look, at the time of contracting, the contractor was making clear that in his clarifications that, of course, I'm willing to take the risk for things that are foreseeable as we stand today, but we're not. I think now I might have now my sound back, so I'm sure people will let me know if you can't hear me, and we'll just mute. That's perfect. So it just on tender bulletins and tender queries, the importance of those is laying the trail for asking questions of the employer as to the effect and making your position clear, because often they're not responded to, or they're responded to opaquely, and that can become quite important evidence at the back end of the contract when you're seeking to deal with a very onerous clause such as the one that Julian was describing. Julian, do you want to add anything in terms of that sort of the tender bulletin, tender query stage?
Yeah, and I think that's a very good point, Jed. And I would, I totally agree with you. So when you are faced with these type of onerous clauses, or there isn't the flexibility to change the standard terms and conditions, which can happen, especially when you're dealing with very large organizations, then the tender bulletins, as you progress through the tender, are a perfect place, like Jed says, to actually record your interpretation of what this clause means and the limits and all these kind of things, that can just offer that additional layer of evidence that when this clause will be discussed, that's setting out what you believe the position was. And also, ideally, you want to get the other party to agree with that's how it should be interpreted as well through the tender bulletins. One point I would say on this as well, that is, if you can actually get the tender bulletins bound into the contract, which isn't unusual, this will also help you. Although it varies between different jurisdictions, but that is another point that I would make, is that if there are some key tender bulletin points, these should really form part of the contract as well, and that will help you with defending the position.
Great, thank you very much, Jed and Julian. That's been really insightful. So now let's move on to the next slide, which is where I'd like to touch briefly on what we mean by off-taker risk event and change in law. So as you can see from the slide, this is another example from a regional solar PPA. And off-taker risk events is an exhaustive list. So meaning that if an event is not listed there, then there is no protection afforded under the contract. Helpfully, this specifically refers to change in law and any action or failure to act by government. What do we mean by change in law? Here is an example of a drafting again from a regional PPA. And as you can see, it's a fairly broad definition. It does cover any new laws, any amendment to those laws that occurs after the bid submission date. Importantly, it must result in changes or a repeal or amendment of the requirements for the particular project concerned. And what do we mean by law? That is another question that will come up. And helpfully, again, on the left-hand side of the slide is the example from a regional PPA. And it is a very broad definition. So law here includes license, orders, rules, decisions, codes, etc. In contrast, if you look at the FIDIC Silver Book, the definition is far narrower, where it doesn't specifically refer to things like codes and licenses, etc. So I guess the question here is a number of the actions by government that's been taken in response to COVID-19 has been issued by way of directions, orders, etc. Do these fall within the definition of law is a question that you will need to ask. And I think in our view, because they do have the effect of being mandatory in nature, there are sanctions that are imposed if you fail to comply with them. Arguably, they would fall within the definition of change in law. And I guess here I'd like to now talk about my next question, which is what exactly do we mean by the law? Because when we talk about a contract, there is a provision that will deal with what is the governing law of the contract. And often we see that being English law or some other law that the parties have agreed would govern the interpretation of the contract. However, the project itself could be done in a totally different country. So if I could just ask you, Jed, what do you think means by relevant law?
Thank you, Gurmeet. I think if we take FIDIC as the example, often there are two types, as Gurmeet was saying. You've got the law applicable to the contract, which governs. Are we on mute? On mute.
Yeah, just so.
Yes. Okay, I've jumped now back on to being Gurmeet because the sound dropped, so apologies. The point I was just making was that over the course of the pandemic, what we've seen is the arguments around whether if a supplier is in a different country and the laws there change and stops them performing, what is the effect in terms of being able to rely on a change in law? And the view, certainly from my point of view, would be that's going to be difficult because the place of performance is generally the country where the project is being constructed and the contract performed, and therefore the change in law in a country where a supplier is providing a piece of equipment, etc., is unlikely to fall within the definition of change in law. So you're very much looking at changes in law in the place of performance, or that depends on your contract, and not changes in the law governing the contract, i.e. the law governing how, rights and obligations under the contract. And so it's really important to look at that. And of course, every jurisdiction, depending on where your project is, will have had different laws and with varying degrees of effect. But you're always looking generally at the place of performance. I'll hand back over to Gurmeet, and sorry for the sound dropping.
Great. Thank you very much, Jed. Apologies for some of the technical issues we are facing, but moving right along, I'd like to now just talk briefly about the relief that you can get for these sort of claims. So again, we come back to the contract, because the contract is the starting point. And in most of the solar PPAs that we have seen, the contract itself is fairly detailed, where it provides for relief both for natural force majeure and off-taker type risk event. And the relief is normally divided again into pre-commercial operations and post-commercial operation period. So for the pre-commercial operation period, the usual position is for natural force majeure events, there is an extension of time but no cost granted. And in contrast, for off-taker risk events, you would get both time and cost. The position is slightly different if you're talking about post-commercial operation, where usually there is some form of relief by way of deemed payments, or at least some element of deemed payments in the case of natural force majeure, whereas for off-taker risk event, you get the full deemed energy payments. In contrast, in FIDIC, we do have provisions that provide for extensions of time and additional costs. And FIDIC itself doesn't differentiate whether it's natural force majeure or off-taker risk events. So there is one slight difference. So I'd be interested now to hear from Julian, if I may, on what other sorts of relief you're seeing from the practice in this region.
Thanks, Gurmeet. One of the things that we're seeing, and if you could just move it on to the next slide, because I've just got some bullet points on this, and I've just what I've done is dug out an example of what we saw. So we're seeing different things in the market, but one of the things that I saw recently, and I just wanted to share this with the group, was there was a contractor and an operator working on a project. I won't digress any more details than that, but it was in an operational environment. So there was concerns with how COVID would not only affect the project, but some of the operational requirements that were going on around it. And the contract between the parties had a force majeure clause, and the impact of COVID was covered by this clause. Now, what was actually happening on the site was the contractor was actually following the legal requirements and best practice to deal with COVID-19. So he was taking precautions with the works, but he was still progressing, albeit it was disrupted and he had some issues. Now, what happened was the employer made the decision that he actually wanted the contractor to demobilize completely from site. Despite the contractor showing him, look, I am dealing with COVID-19, we are taking precautions, and these were very restrictive precautions. It wasn't sort of minor things, they really were dealing with it. Despite all that, the employer said, no, I want you off site. So the contractor had to demobilize very quickly. He did try to make he had tried to have some discussions and about what he should do with his plant and equipment and the works that were, ongoing and how to protect them. But the instruction was clear that he had to get off site within a very short period of time, which meant not only were his plant abandoned, but the existing works were abandoned as well. And I think that in retrospect, I think I can say this, the employer acted very quickly without really looking at the terms of the contract, without trying to find alternative solutions. And what this meant was that he actually exposed himself to the suspension provisions in the contract. There was an attempt to try to utilize the force majeure mechanism retrospectively, but this really didn't work. And therefore, what the employer actually opened himself up to was he had actually issued a suspension order for the work. This meant that not only was he exposed for the time impact, but the cost impact as well. There was a demobilization, a period from demobilization, to remobilization of about 3 to 4 months. And the plant was affected, and also the works were affected. So what he ended up doing was actually exposing himself to a large amount of costs. And I just think this is an example, and I wanted to share it with the group, where I don't think the employer really went through all the mechanisms and the opportunities that were available to him on their contract, made a very quick decision, albeit he probably was trying to do the right thing. But in the end, it ended up with him exposing himself to a large, not only extension of time, but costs as well.
Great, thank you, Julian. And I think, Jed, you had some thoughts on what other claims were available at law.
Thanks, Gurmeet, and I'm hoping everyone can hear me. I'll keep an eye on the chat box in case that changes unexpectedly. The only other point I'd just make is that there's been quite a lot of focus in the Middle East region on code. There are similar provisions in the UAE civil code, and indeed many other of the civil codes in this region. The provision breaks down into 3 parts, really. The first is the offence got to be unforeseeable at the time of contracting. Second, the effect of the event has to be to cause the performance of the obligation more burdensome. And note, it doesn't require it to be impossible. And just to link back to where Gurmeet started, Gurmeet referred to force majeure under UAE law, and that does require impossibility. So it's different when you're looking at this type of hardship provision. It is a lesser hurdle in that respect. And the third ingredient really is it's got to threaten the party that's seeking to rely on it with serious loss. If you satisfy those 3 ingredients, then the court, or arguably a tribunal, if you've got an arbitration agreement, is entitled to reduce the burdensome obligation to a reasonable limit. It doesn't necessarily mean you're going to get full compensation, because they will generally take into account the effect on the other party as well of the change in circumstances and try and balance the losses to both parties. But it is an option if under your contract you have not got the recourse to financial compensation. The most difficult bit of these types of provision is demonstrating serious loss. It's not just any loss, and the commentaries in relation to this suggest you've got to show something that it goes beyond the extent or type of loss that the parties might reasonably expect to have encountered on this type of project. So you've got to go some way. In France, for example, this is usually demonstrated and has been looked at from the point of view of quantifying the loss relative to the contract price. Is it a significant percentage of the contract price that's been suffered? And that's one way in which some jurisdictions have gone about looking at this. The last point, just to make clear, is that as you'll see from the end of the provision, it says that any other agreement to the contrary shall be void. So you can't contract out of this. So if your contract was subject to Omani law and you've got an exclusive remedies clause, you can't. That won't be effective against this provision. Similarly, it's a similar position in the UAE, and as I say, in some of the other Middle East jurisdictions. So they're the points I'd just make there. That it's an alternative option to look at outside of your contract.
And if you can continue about variations.
Of course, yeah. So the other, when we're looking at grounds for claiming, I mean, Julian touched on suspension. The other theme we've seen over the past months is where you've had a change in law that the authorities have issued and that stands as a change in law, but the owner or developer on the particular project adopts a more onerous provision and imposes itself additional restrictions that affect your labour and movement on site, etc., and that causes you loss. In those circumstances, what we have seen is a move to construe that as a variation, because effectively the owner is instructing you to do something that goes beyond what's required to comply with the law, but is affecting the nature and sequence of and timing of your works. Obviously, it depends on the width of your variation provision, but again, in FIDIC, often it will include changes to the sequence or timing of the works, and one can then rely on those sorts of provisions to introduce either a disruption, loss of productivity type claim, or I'm going to now switch to Gurmeet's laptop. Mine's lost connection, but this route then allows you to potentially advance a claim under the contract, under variation provisions, in order to recover that loss in circumstances where the owner has gone beyond the changes in law in the particular place where you're performing the works. Julian, I don't know if you had any thoughts in terms of the issue I was just dealing with. Please feel free to input.
Thanks, Jed. No, I think you've raised the points you raised are very valid. I think this is definitely an area that I'm seeing in the issues that we're seeing in the market that is being looked at. I think there is often a requirement from the owner, because again, I talk about some of the operational environments which some of the projects are being built in, you know, that they have this wider concern about the wider facilities and what they're producing being impacted. So often there is this requirement to go above and beyond what would be expected either under the law or with various guidance from the government. So I do think it's an area that I'm continuing to see.
Thank you very much, Julian. I guess I've just got one question that I'd like to pose, and either Julian or Jed, if you feel free to answer. What are the sort of defenses that you are seeing being brought in COVID claims from owners? So I don't know who would like to take this first, Jed?
Sure. And I'll just borrow Gurmeet's laptop again. So in terms of defences, there are probably two main themes that we're seeing. The first is procedural defences, as you will see on the slide. So obviously common in all types of claims where you're dealing with a FIDIC type regime, it's certainly at the sort of EPC contract level, is the time bar, the time bar limit on notifications of claims. Generally, you will see that force majeure, but also change in law in particular, because obviously change in law generally is the one that opens up cost, is subject to notification under the contractor's claims provisions. And so what you're seeing is a real tightening up from the employer side, saying, well, look, it may well be you've got a claim for change in law, but you didn't notify within the 28 days of that arising, and therefore we're not going to consider the claim. So that's been the first area of defence, which I guess is not particularly surprising. The other issue that we've seen in change of law claims are arguments as to whether or not a particular regulation or circular have the force of law. and the owner-employer trying to shift the balance to the contractor to prove that the particular law they rely upon has the force of law, but also identifying and providing that law to the owner to substantiate their claim. And obviously the idea there is to cause as much difficulty to the contractor as possible in advancing their claim. And as we know, through the early stages of the pandemic, these directions, regulations were being issued in a very sort of informal way. And so it's very hard to track down the exact regulation or circular that was being articulated through, for example, Twitter, etc. So that's one side of things. Julian, before I come on to equivalent project relief provisions, do you want to just deal with the sort of hurdles that you're seeing in relation to making extension of time claims in particular?
Sure, Jed, definitely. I mean, one of the points that I put up here, and I just think it's an important thing, is that now the parties that are entering into contract, I think, are understanding claims more and more and understanding extension of time analysis. We're often seeing now in contracts that the delay analysis is actually defined in the contract. So, for example, it might say during the course of the works, you're to do a time impact analysis, but once the work has been complete, you do a more retrospective analysis, such as planned versus as built. And I just wanted to bring this up because I've seen recently a party not follow the provisions in the contract and put a claim together using a different method that is under the terms of contract. And so the other side has come back very quickly and said, well, look, you've made a submission, you've set out your analysis, but this isn't as per the terms of the contract. You are supposed to be using time impact analysis in this case, and they used a very simplified form of impact it as planned. So I think this is an important thing that you need to consider when you're dealing with the claim, to make sure that if the contract, and not all contracts go into that detail, but if there is some detailed provisions, especially about your demonstrating your extension of time, especially about the analysis, then you should really try and follow it, because it's just another thing the other side can bring up as a rebuttal.
Thanks very much, Julian. And just conscious of time, what I'm going to suggest now is just moving on to a related topic that we were discussing before the call, which is in terms of common defences to COVID claims. You were just talking then, Julian, about requirements in terms of presenting your extension of time claim. Certainly the other thing we've seen following on from the notice issue is this necessity to provide particulars as to the specific effect of COVID, i.e. the fact that it's occurred doesn't mean you're automatically entitled. And I wondered whether from your point of view you might just share some thoughts on that.
Yes, no problem at all. We jumped a slide there, but I did have...
I'll move back. I think you wanted to share this one. Yeah.
Just to touch on this, HKA has a database called Crux where we analyse causes of disputes, all the ones we've dealt with, and it goes back quite a period now. I've just put up some examples of regarding solar projects, what we've seen as causes. I'm not going to go into this right now, but just to make you aware of it. And if anyone's got some follow-up questions, please raise them or can speak to me afterwards. If we just move on to the next slide, just regarding, the common defences and put it in this context, one of the key things is particulars. You really must go into and demonstrate the cause and effect. If you don't do this, and I'm sure Jed will back me up on this as well, your claim will fail. You've got to show that causal link, and it's absolutely fundamental. And to do that, you will need good records such as schedule data and your daily progress reports in particular. And one of the things that I just want to very quickly touch on that we're seeing is now that we move from a period where a lot of jobs were maybe stopped or the progress really reduced because of the impact of COVID-19. And we're entering into this phase where people are aware of COVID-19, the works are trying to get going, but there's heavy restrictions, especially in the context of demonstrating disruption. Your daily progress reports must clearly set things out in a certain manner. Otherwise, you won't be able to demonstrate the cause and effect. And I'll stop there because I know we're short on time.
Yeah. Great, thank you, Julian. I'd just like to now introduce another topic, and this is on mitigation. And if I may ask Jed, so do you see many clauses impose a duty of to mitigate? And what do we mean by that? How far does, duty to mitigate go?
Perfect. Thanks very much, Gurmeet. So I think when we started the session, Gurmeet went through a couple of example clauses, and by and large, and this is reflected in the FIDIC forms, there is generally a duty, contractual duty, to minimise or mitigate delay. And what we mean by that, or mitigate the impact of the force majeure event, what we mean by that is to take measures not to exacerbate it, but it very much depends on the drafting of the clause. So some clauses will say a general duty to mitigate, but don't expressly state that you've got to incur cost in doing so. Others will say you've got to mitigate, and you've got to take all reasonable measures available at your own expense to do so. And the example clause I put up there is one from a contract in the region, and you can see there that as a matter of the contract, you are being asked to expend cost in terms of reducing or minimising the effect of the force majeure event. The real issue there is how far do you have to go? And what we've seen very much in this region are owners and employers seeking to use that mitigation clause to say, well, it's not just enough that you're minimising the impact, but in fact, you've got to reduce the delay that's being suffered. And effectively, that translates into, if you're not careful, acceleration. And so there's been a great deal of debate between owners and contractors around the extent of that obligation. Certainly, as a matter of English law, it's generally reasonable costs. It's not do anything at any cost. It's reasonable costs, and those costs are generally recoverable as damages. I've put up there the Society of Construction Law Delay and Disruption Protocol excerpt. It's important to note this relates to employer risk events. Obviously, when you're in the world of force majeure, it's a neutral event. But I think it's quite useful in terms of the principle that it's trying to articulate, which is, yes, you've got a general duty to mitigate and not to exacerbate the effect of the delay event. But it doesn't go so far as to require you to add extra resources or work outside your planned working hours, i.e. that's the world of acceleration. And I think that's particularly something we've seen, as I said before, an area of hot debate between contractors and owners at the moment.
Great, thank you, Jed. And that brings us nicely into our next topic, which is on acceleration. So if I could ask Julian, are you seeing many acceleration claims as a result of COVID-19? And also if you could touch briefly on the types of costs and losses that flows from COVID-19 from your experience.
Sure, Gurmeet. Yeah, we are seeing the discussion between the parties around acceleration, trying to recover some of the impacts from COVID-19 or some of the other forms of relief we've talked about. What I've done is I've put up here just some key points, because I'm finding it's a common theme, just how sometimes the parties are dealing with it, and you need to be careful how you deal with this issue. So first of all, you must demonstrate an entitlement to an extension of time to have a conversation around acceleration. And really, after that has been established by the parties, really what you want to do is both parties should review how the schedule can be accelerated and come to some kind of understanding of what requirements are needed from both sides to accelerate the work. And it needs to be realistic. And then the contractor really needs to set out and demonstrate what additional resources he's going to bring to meet that requirement. And then after that has been done and the costs have been declared for that, then there should be a very clear instruction given by the employer or operator. What you really need to avoid, which sometimes I see, is you go ahead and you do recovery measures without the following the contract or the above, and it becomes very difficult to retrospectively show entitlement to acceleration. So I would really encourage everybody to really follow those key points above when you're moving through this topic. In answer to your second question, and if we can just move on to the slides, just again, I put up some key points, and I'm going to go through these quickly because I'm aware of the time where we are at the moment, but just some key points just to consider. You should follow the provisions in the contract at law. So whatever relief you're seeking, there normally is some, in most contracts, some guidance on the type of costs you recover and the appropriate mechanism to value those costs. There should be a definition as well of what cost is as well. That's always very important. A lot of contracts deal with it. Sometimes it's not dealt with, and that can be a challenge. You should always consider what is the appropriate mechanism. We've had some discussions recently on different issues that we're dealing with, whether it should be costs or if there's a schedule of rates in the contract. And especially when the variation clause is very wide, it might be that the rates are applicable. The other thing, especially with costs, when you're dealing with costs, is that your records, and obviously that's very key. I think it's very important that the project finances records are set up accordingly at the start of the project. So one of the things you should really consider is when you're, when you've won a contract, you should look at how, if the issue comes up, how you are, what you are required to demonstrate from a cost point of view, and make sure that the various parts of the company are recording the costs in a friendly format that will comply with these obligations, and it's clear to demonstrate. You need to record them through the works as well, and during the duration. That's very important. One of the issues that I've seen come up with costs of when you're in a joint venture, that can be difficult to actually demonstrate actual costs depending on how it's set up. So again, if you're entering into a joint venture, I think you need to consider that. And one thing I would just mention is to always be careful in the level of substantiation. Of course, you have to substantiate it, but I've seen sometimes people go too far. Again, it's the test is always on the balance of probabilities, and so there is normally set criteria that you will need to set out to demonstrate the costs. And the parties should be discussing that and making sure that it doesn't become too onerous. And that's it. Those are my points on that question, Gurmeet.
Great, thank you very much, Julian and Jed. That's been really insightful. So I'm going to stop sharing the slides now. And in the last 5 minutes or so that we have, what I'd like to do is to take some of the questions from the audience. So, so I'm just going to have a look at some of the questions. So one of the questions we've got from Martha is, if the event is foreseeable but unavoidable, can it be considered to be a force majeure under English law? I don't know if Jed, you would want to take that one.
I'm very happy to do that. Again, I'm robbing Gurmeet of her laptop. I mean, it's a really good question. Under English law, there isn't a concept of force majeure, as Gurmeet touched upon at the outset of the session. And so the only other doctrine, if you're trying to get out of the contract, is the doctrine of frustration. And that's an incredibly difficult claim to succeed on. To succeed on the doctrine of frustration, first, the event's got to occur after the contract was entered into. That may well have happened in the contract you're looking at the moment. Second, it's got to be beyond which was contemplated by the parties, i.e. unforeseeable at the time of contracting. Thirdly, it's got to render performance impossible or radically different. And it's generally that next bit, the impossibility, that's the very high threshold to succeed on. The effect of frustration, English law, common law, is actually to bring all obligations to an end. It doesn't suspend performance. And that kind of just illustrates why the impossibility radically different element is such a high threshold, because you're effectively bringing the contract to an end because you cannot perform it. In that context, you're often better served by seeking to operate the contractual force majeure provisions and or change of law provisions in the contract where your contract is governed by English law. Thank you.
Thank you, Jed. I think we've got time for one more question, so I'm just going to scroll through. So there was one on the parameters that constitute the definition of a force majeure claim, whether political or natural. Some PPAs provide cost relief only on political FM. Appreciate if you can give some practical examples. So I think just in relation to that, as we've shown in the slides before, the contract itself is quite clear as to what constitute political or natural force majeure events, and things like change in law, for example, will often fall into the category of a political force majeure event. So in the examples that Jed talked about, if you've got directions from government imposing like lockdowns, for example, and that has the force of law, then arguably you will bring your claim under the provisions of the political force majeure rather than a natural force majeure, because from the point of view of the contractor or the developer, the relief is you get both time and cost. Whereas if it's a natural force majeure event, which is a broader definition, arguably, because anything outside the reasonable control of a party would fall under that category of natural force majeure. The problem there is the relief is more limited, so it's time only rather than cost. So, we're obviously happy to have a further discussion if you'd like to discuss this in more detail, and please feel free to contact us after this webinar to discuss it in more detail. I don't know if any of the other speakers had any other questions they were happy to answer briefly. I think there was one. The first question deals with tender bulletins. Don't know if Julian, you had any view on that?
I think this is actually more a legal question, so I would probably defer to Jed on it. I saw that one come up. I mean, yeah. The only point that I would make is that when I was talking in the context before, it is very much depending on the jurisdiction. And also I did mention as well the importance of binding those tender bulletins into the contract as well, which I think would help with this issue. But Jed, do you want to wade in on this as well?
I think your point about making sure they form part of contracts, absolutely right. It's probably a distinction as well between common law and civil law jurisdictions. In civil law jurisdictions, you can generally rely upon what was said by the parties at the time of negotiating, particularly where you've got an unclear or uncertain clause, and so it doesn't necessarily preclude you. Under English law, the position is slightly different. It's the parole evidence rule, which generally precludes you from relying upon that evidence in order to further an interpretation of the contract. But yeah, good question.
Great. Well, thank you all very much for that. I see we've reached the time allocated for our webinar today, and certainly we don't want to hold you any longer than we need to. I'd like to thank everyone for joining in, and as mentioned earlier as well, the webinar is recorded, so I'm sure you can contact ATA Insights if you'd like a recording of the webinar, and please feel free to get in touch with us separately. We're very happy to answer any further questions that you may have. And I'd like to take this opportunity to thank Majeure and ATA Insights as well for the opportunity to speak today. Thank you all. Goodbye.
Thanks. Thank you.